Perfect. Okay, I'm going to go ahead and share my screen. Let's go ahead. Do, do, do. And I'm going to be moving our little pictures around so I'm not blocking the text. I'm just going to go ahead. So just a fair warning. I hope I don't make anyone nauseous. All right. Good morning.
Good morning. Thank you everyone for joining us and happy Friday. Thanks for joining the presentation, The Ins and Outs of Working with an Advocate, presented by me, Alicia Schuler, and my colleague, Bridget Garrity.
Good morning, everybody. Again, happy Friday. We're going to go through our slides, and please feel free to ask questions in the chat feature. At the very end, we'll go through and hopefully have some answers for you. But before we begin, we want to thank Jan and ARC of Prince William's Circle of Support. We hope that throughout this presentation, you gain some information, knowledge, and feel confident as you make decisions for your child.
So good morning. As I mentioned earlier, I am Alicia Schuler. I am a special education advocate with Belkowitz Law based in Fairfax. I'm also a certified special education teacher. I attended Iona College in New Rochelle, where I obtained my bachelor's in elementary education. I then went on and earned my master's in mentally physically handicapped from California University of Pennsylvania. I worked as a self-contained autism teacher for Loudoun County, grades K through 2. And while living in Pittsburgh, I taught middle school life skills. And just a couple of more personal things about me. I've lived in Virginia since 2014. I live in Gainesville with my husband, Mike, and my 2 dogs, Kaylee and Trudy. I love running, reading, and gardening. Gardening and cleaning are 2 of my biggest stress relievers. So just a couple little fun facts about me.
You're always welcome to come help clean my house, Alicia.
Will do.
I'm Bridget. Just a little bit about my background. I am from St. Louis, Missouri, and I studied elementary education at St. Louis University, or SLU. I moved to Northern Virginia about 10 years ago. I can't believe I've been here that long, because I went to grad school at GW, and I participated in a program that focused on special education for students with emotional and behavioral disabilities. I worked in Fairfax County Public Schools in different capacities, and I continue to hold my Virginia teaching license in special education. And like Alicia, I also work at Belkowitz Law as a special education advocate. A little, personal note about me. I'm a really big nerd, and I love, reading articles and newspapers about the news. I have a total love-hate relationship with politics. I love listening to music. I grew up playing piano and guitar. And like Alicia, gardening is a big stress reliever for me. I live in Centerville, and I live with my husband, Tim, and our almost 19-month-old, just 19-month-old daughter, Nora, who really keeps us on our toes. She's a little bossy gal.
And she's adorable.
Thank you.
So just some things that we have 4 different areas that we're going to cover today. Lots of information. So, we don't want you to be overwhelmed at the end of this, but we have a lot of information in a short amount of time to present. We feel the best way to break the information up is into what is a special education advocate, when and why people hire advocates, what to expect if you hire an advocate, and if you cannot afford an advocate, some really important things that you need to know. So our first section is, what is a special education advocate? So an advocate is not the same thing as an attorney. An attorney has specialized training and understanding of the law. While an attorney may also be an advocate, most advocates are not lawyers. There is not a specific certification or licensure that's required in order to be an advocate. Anyone can call themselves, herself, or himself an advocate, so it is extremely important to ask questions should you hire one. Most people who work in the world of special education have a story that led them to this calling. If you're hiring an advocate, you want to ask about their background. Are they a savvy parent who is successful in advocating for their child? Maybe they're a former teacher, a psychologist, a counselor. You just want to know what brought them into advocacy. You also want to ask, does this person have specific training? Are there, specific memberships, certifications that they hold? So as Bridget and I both mentioned, we're both former special ed teachers. We're still both licensed special education teachers in the state of Virginia. For example, when you're talking about memberships, both Bridget and I were members of the Council of Exceptional Children, also known as CEC, and the Council of Parents, Attorneys, and Advocates, known as COPA, and licensed special education teachers.
So, if you do hire an advocate, he or she should have an understanding of special education in general, but that includes a lot of things. So we're going to break that understanding up into 4 sections. The first are the special education processes. The second are the regulations. Third is state and federal laws. And finally, important court decisions that impact all of the above. So when considering the process within special education, there really is a cycle. And this cycle is fair. It's the same whether or not you're going for a 504 plan or an individualized education program or an IEP. This particular graphic is talking about an IEP, but again, you're still going to have these steps for 504. So the first is the referral. If a district suspects a child has a disability, then they're required to make a referral. School districts have an obligation to identify students with disabilities, and this is called child find. People outside of the school, like parents, can also make a referral. Once the referral is made, we get to the second piece, which is a team will meet to determine whether there needs to be an evaluation to determine whether a student has a disability. Sometimes families have private testing that they take and that leads to this piece, or the school will determine which assessments are needed in an evaluation. The third piece is eligibility. So the team will then meet after they have all of the data and determine whether the student has a disability that entitles them to eligibility underneath ADA or the Americans with Disabilities Act for a 504 plan, or if going the route of an IEP, that would be under the Individuals with Disabilities Education Act or IDEA. And just a fair warning, world of education and special education in particular, there are lots of acronyms. So we're gonna do our best to lay out what the acronym is, but we'll also get into that later because it can be very overwhelming. If a student's found eligible for an IEP, there are 14 eligibility categories. And some of those categories you're going to hear, autism, specific learning disability, visual impairment, hearing impairment. There's 14 of them, but you go through the criteria to determine that eligibility. The next step, if a student is found eligible, there's the development of the IEP or the 504 plan. The fifth is really the implementation. It's that instruction and monitoring of the IEP or 504 plan. And then finally is the annual review. Teams are required to meet at least once annually, but as a parent or guardian, you can always request a meeting. That's one of your rights, to request one.
Okay, state regulations. Thanks, Bridget, for that information. So while there are federal laws that relate to special education, each state functions slightly differently in various processes. So it's important to know what your rights are in Virginia, especially if you've just moved here from another state. There might be some slight small differences. So in addition to understanding the regulations in Virginia, it is important to understand the federal laws that are consistent throughout the country and have a heavier weight. The Individuals with Disabilities Education Act, or commonly referred to as IDEA, outlines the laws regarding individualized education programs, IEPs. Students identified with a disability are entitled to a free, appropriate public education, FAPE, in the least restrictive environment, LRE. Sorry, lots of acronyms right there. These important acronyms have really powerful implications. So for FAPE, free means at no cost to the parent. Appropriate means individualized to that student to ensure progress. Public is for public schools. And education means instruction in a student's areas of needs. It's important to know that education is not just academics. I think teams often just focus on the academics, but it's not just the academics. It also includes emotional, social, physical needs of a student as well. As an educational benefit law, IDEA offers additional services and protections for those with disabilities that are not offered to those without disabilities. Section 504 of the Rehabilitation Act prohibits discrimination on the basis of a disability. So if a student has a 504 plan, it is under this law. 504 is designed to level the playing field for individuals with disabilities. I think that's really important to remember that. Its purpose is to ensure that individuals with disabilities have the same access to education that individuals without disabilities have. It does this by eliminating barriers that exclude individuals with disabilities from participating in protected activities, including a free and appropriate public education. Americans with Disabilities Act, or the ADA, protects individuals with disabilities. This is not specific to education, it's just in general.
Thank you, Alicia. And I'm going to try and move this so I'm not blocking the oh, that's wonderful. I'm just going to leave it there. All right. So the next piece we want to talk about are the important court decisions. And the courts continue to make decisions that impact the interpretation and implementation of federal laws and regulations. So these are two very significant Supreme Court decisions that are important to know and understand, and I'll explain. The Supreme Court provided interpretation of IDEA's requirement of public schools to provide students with FAPE in these two cases. So this first case is the Board of Education versus Rowley. This was in 1982. For decades, this Rowley decision was considered the precedent regarding the interpretation of what appropriate means. The decision stated that a student was receiving FAPE if progressing from grade to grade. It is known for using the analogy of the Chevy versus Cadillac. So in using this analogy, they were making the, they were implying that a student is entitled to a Chevy or the basic or minimal type of education and not to a Cadillac or the best. So, you know, not the greatest. But here comes Andrew F. versus Douglas County School District, which is in 2017. And it was a game changer and very significant decision that it changed the precedent that was set by Rowley. The decision stated that a school must offer an IEP that is reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. So that's more than just from grade to grade. It stated that a student was entitled to more than the minimal or the Chevy, and that an education program must be appropriately ambitious. Moving from grade to grade was not enough. Even though this decision was in 2017, many school districts still rely on this Rowley decision when discussing appropriate in a child's progress. So it's important to know really what the updated law states, because we encounter this a lot when we're working with families. So you know that if you hire an advocate, he or she should have an understanding of special education. But when and why do people hire advocates? It's really important to know that you can hire an advocate at any time and for any situation. It's not just when things are contentious. These are some of the reasons people call us. Advocates can be brought in whenever, like I said. People hire advocates when looking for extra support, whether that's for an IEP meeting, eligibility, 504, maybe there's a discipline issue. We get those a lot too. There's lots of reasons people need that extra support. Parents and families are often overwhelmed because they're not familiar with special education or the processes. Maybe their child isn't making the progress, or they're stuck in child study. Or they just simply want to know what the options and possibilities are moving forward, because schools are not going to tell you all those options.
Thank you, Bridget. That was very helpful information. And like you said, many of our clients come to us for those exact reasons. So what can you expect when you hire an advocate? As advocates, we are an ally. So parents are often outnumbered and overwhelmed. It can be very intimidating to sit around a table with a room full of people who specialize in education. So oftentimes, even if I go to a meeting with a client, it could be, the parent and I, and there's 10 other people around the table. It can be very intimidating and overwhelming. As an advocate, we are there to support you. Schools don't always explain all of the options to parents. And as an ally, advocates, we are there to ensure you understand all of your options. As advocates, we are looking out for your best interest and your child's best interest. So, options, parents aren't always presented with every single option, maybe the option that's convenient to the school. So it's important to have somebody there that knows every single option that you're entitled to.
Right. And, just to piggyback on that, you don't know what questions to ask if you don't know what the options are. So a lot of times families are stuck because they're like, oh, I didn't know that was even a possibility where I could ask for that. So that's where an advocate can be really helpful. An advocate is also a data analyst. An advocate should be capable of reviewing an evaluation, IEP progress reports, IEPs, formal and informal assessments, all the different pieces of data, and there's surely lots of them. And in analyzing that data, an advocate can help determine appropriate goals, accommodations, and services for a student. The data is incredibly valuable, and an advocate can analyze it and provide you with the best information for you to make the best decision for your child.
And something just to piggyback off of that, Bridget, is oftentimes, we're reviewing documents and we notice that, wow, this goal is repeated for 4 or 5 years, or, 2 years ago, they mastered this goal and now we're going backwards. And so it's really important to have somebody that's able to really, look at that data with a fine-tooth comb and examine it. And what does it tell us?
Yes, and that too, that the same goals from year to year, that's where we go back to why it's important to understand NJREF decision. Because the goal, this child should be making progress unique to the student's needs, and the goals must be appropriately ambitious. So that's really good to point out. Thank you.
So as advocates, we validate your concern. So you as the parent, you know your child the best. Go with your gut. If something feels off, it probably is. Advocates validate your concerns while also being honest with you about the situation. As advocates, we can and will communicate your concerns by being a link between you and the school. Sometimes there's been some mistrust between the parent and the school, and we kind of come in and we're that link to kind of help rebuild some of that. Sometimes families are uncomfortable pointing out maybe some issues that have happened. They feel like they're going to be retaliated against. So as advocates, we can take that burden off your shoulder. Let your advocate be the bad person in that meeting. In addressing your concerns, an advocate can help you plan a strategy.
An advocate should also be open to collaboration. This is very important piece. And, the IEP process, the special education process in general, is all about collaboration, and it's supposed to be a collaborative process. So when you bring an advocate in, you really don't want someone who's coming in and going to make things more contentious. Advocates, are oftentimes kind of a mediator, like Alicia said, kind of that link. And that really have to be careful about that balance between working with the school and maintaining that relationship while also holding them accountable and reminding them of their responsibilities. So, there's that part about, working together, but also being assertive, because as an advocate, it's our job to point out the mistakes or what needs to be improved. And not schools don't always like an outsider coming in and telling them these things. But really, our goal is to make sure your child is getting what he or she needs.
Okay, so also as advocates, we catch mistakes, right? So an advocate will review documents for accuracy. Sometimes things discussed during a meeting are not always documented as they should be. Documentation is key. Any request made by you must be documented accurately. If it's not documented in writing, it didn't happen. So going along with this, sometimes schools will, call the parent and say, oh, hey, Johnny did this in school, or this and this happened, or might have a conversation with you when you come to pick up your child or, drop them off at school. You want to make sure that you create that paper trail. So if, someone from the school did call you, or you did have a conversation on the side with the teacher, whoever in the school, you want to make sure that you follow that up with an email and just say, thanks for the call today. Per our conversation, I want to make sure I understood X, Y, and Z. Because now you have that paper trail. Oftentimes schools don't like to put things in writing, but like we said, if it's not in writing, it didn't happen.
That is unfortunately the case, and we see all the time. An advocate asks questions. We ask the hard questions. We use our knowledge and understanding to know what questions are necessary to gain the information that's needed. So we'll ask the hard questions like, is the student making progress? How do you know? Where's the data? Where's the data is my favorite. These are questions that should not be difficult for the school to answer, but oftentimes they're going to hesitate, especially that data question. We want to make sure we're getting the information and also holding the school accountable, because it's the school's responsibility to educate your child. What are they doing? A lot of times school will go to meetings and the school staff will really kind of put the responsibility on the parent, or, like, well, they should have been doing this or whatever. It's not your job to educate your child. And again, the school's responsible for the education. That's not just the academic piece.
So also as an advocate, they are a teammate. So this goes back to earlier when we talked about, being collaborative. So when you bring an advocate, that person, he or she, they are another member of the IEP team. It's important. So their input is important and helpful in guiding the flow of the meeting. So an advocate is there to remind the school that you, as the parent, are a valuable required member of the team. I can't tell you how often I have had to do that at meetings because the team will make decisions and they won't include the parent. And I have to remind them, oh, the parent's here. The parents are, a valuable team member. They know the child the best. An advocate will make sure that you're not left behind or kept out of the conversation. And so oftentimes parents have their own data. That's important data that needs to be shared and considered at these meetings. You also have observation. So your input is key and needs to be considered. I know the school does, different assessments and those are important, but what you bring to the table, your data and your observations is equally as important and needs to be considered.
Absolutely. I think that's a really, really good point, Alicia. And as far as what kind of data you have, is your child coming home and, having full on meltdowns? That's important information to know, because is there something that's triggering that at school? Is your child spending hours doing homework? That's important to know, because there may be, difficulty reading or tracking or staying organized. Those are all things that really would need to be addressed within an IEP.
Or is your child not wanting to go to school? Like
Yes.
that's another important observation. Or are they coming back and wow, they have marks on their arms or whatnot? It's just those observations that are extremely helpful to bring to the team.
Yeah. And, one of the things, with COVID and, I know our firm is seeing a lot of students with increased anxiety, and we're seeing more and more school refusal. The school's responsible and has an obligation to figure out how to get your child to school. That's something really important to know, because that is one of the big issues where we see the school team putting it on the parents, but really have to go back to, there's a need there that needs to be addressed. And why is the student feeling this way? What made that happen? So it's something good to know. So as an advocate, we are also educators on special education. Like we said, there are a lot of acronyms. These are not all of the acronyms either. These are just the first ones that came to mind when we sat down creating this presentation. It's so overwhelming. There are times where I have to think and I'm like, oh my gosh, what does that mean again? At meetings, teachers and specialists will have their educator jargon that might fly over families' heads. As an advocate, again, as your teammate and everything, we're making sure that you understand what all of these things mean, because in the end, when you sign your type of consent, this is a legal document. Advocates should be able to explain the processes to you so that you are confident and comfortable. Also, special ed advocates really should understand special education needs. Does the advocate know the latest research on strategies for teaching students with autism? Or do they know the characteristics of a student with dyslexia? Does the advocate understand how to determine a developmental delay? So while it's really helpful to understand the laws, regulations, and everything, there is so much as far as the disabilities themselves and how to address them, coming up with different goal ideas, different accommodations, and really figuring out the services and placement that are appropriate. So if an advocate can't answer a question or doesn't know, should at least be able to point you in the direction of resources to give you the information that you need. And I know that's something that we do all the time. And one of the benefits of our firm, we work with attorneys as well. I am never going to give a client what I am guessing is an answer to something. If I don't know, I am going to figure it out, because you really need that accurate information to make the decisions.
Such great information, Bridget.
Thanks.
So we want you to know these tips. So, right, in an ideal world, parents should be able to advocate for their child, and the child gets what he or she needs, and then there would be no need for advocates, right? Unfortunately, school districts don't always do this, and that's why having an advocate can be helpful. It is an additional expense, and it can add up quickly, just depending on your case, on the situation. Different advocates, different firms have different rates. So if you're unable to afford an advocate, it's essential that you know these tips. Consent. So when it comes to signing any type of document, know that you do not need to sign anything at the meeting, right? Schools can be super pushy and say, oh, here, you need to sign this. They get really pushy about getting the documents, especially IEPs. They want them signed and returned like the next day or at the meeting. The majority of the time, there is absolutely no need to sign anything right away. Take that IEP home, review it. Maybe your significant other wasn't able to attend the meeting, share that information with them. Lots of information is presented at these meetings, and it can be very overwhelming. So just taking that time to kind of process the information, look at the document. You want to make sure you read over everything, because it is a legal document, right? And you want to make sure that you feel comfortable signing it. You also have options in how you sign an IEP. You can sign in full consent, right? Which means that you agree with everything that's in the proposed IEP. You can sign no consent, which means you don't agree with anything. You could also sign in no response. That's not something that we suggest, but it is an option. The final one that we do often is partial consent. It's a wonderful option, and schools often do not tell parents about this option. On the IEPs themselves, there is not a line to sign in partial consent, but just know that it is possible. When you provide partial consent, you must be specific about what you agree with, as far as what you're agreeing for them to implement, and what specific things that you do not provide consent to. So for maybe example, maybe your child receiving, 2 hours a month of speech and language, and the school district is proposing to reduce it to 1 hour a month, but you don't agree with that. So that would be something that you could sign in partial consent. What that would mean is that those services would be delivered as they were on the last signed IEP. If you agree to everything, but the removal of services, there's, those are reasons why you would sign in partial consent. You're not going to sign in partial consent because somebody's name is spelled incorrectly, right? It's those substantive things that you would sign partial consent to. Schools cannot make any changes to the student's eligibility or IEP without your permission. Your child will still receive services if you don't sign the IEP. If it's an initial IEP, that's a little bit different because they haven't been receiving services. But if it's an annual IEP or an IEP addendum and the school is pushing you to sign it, I have had some schools tell the parents, you have to sign this in order for your child to receive services. That's inaccurate. That's not correct. Your child is still going to receive services if you have not signed, the IEP.
Right. And they may not be getting the services or goals that are in the proposal, but it still goes back to that last signed IEP, like you said. So there is a lot of paperwork in special education, whether it's IEPs, progress reports, evaluations, eligibility, reevaluation, your handwritten notes. It is so important to hold on to these documents and to organize them. There are a lot of websites that offer some guidance on and recommendations on how to do this. My advice, and I think Alicia would agree, I would have a binder for each school year, where you break it up into sections like the IEPs and the progress reports. If you have like a whole binder that's just the IEPs and a whole one that's the evaluation reports, you're going to be carrying a lot of stuff to meetings, and you really want to have that binder that's so you can easily access things so you can refer to it if needed. Two, that means notes. It could be emails. Let's say that the teacher reaches out to you and lets you know that your child eloped from the building. That's significant, but let's say you're in the meeting and you don't see that anywhere in the IEP. That would be an example of where you could flip to your notes section or your email section and say, you know, Miss or Mr. So-and-so, you know, on this date, you let us know that he or she was eloping. I think that's really important. What can the school do to ensure that doesn't happen again? It's not confrontational. It's just making sure that every area of need is addressed. In addition to all those things that you might have that have been given to you, you can always ask for your child's records. That's really important. And then let me back up a little bit as far as notes too. You have the right to record any meeting that's related to your child's IEP. This is a great thing, especially like Alicia said, if your partner isn't able to attend the meeting, you can always go back and listen. You can go back and listen and make sure the proposal you receive has everything that you discussed. But if you do this, we recommend that you do give advanced warning to the school. A lot of districts have a form that they want you to complete, and they're always going to record too. Let's say you forget, because it happens, people make mistakes. You just have to be able to provide your recording to the school district. So it's really an easy process. A lot of times families get really nervous about recording and they think it's going to make things contentious, but it's one of your basic rights as a parent with a student with a disability. So, but as far as, let's say you're going through all of these notes, all of these documents you have, and you feel like you're missing something, you don't have all of the data, you can ask for the records, and there are two different laws under which you can request these records. The first one is the Family Educational Rights and Privacy Act, which is often referred to as FERPA. So this is a federal law that allows parents access to their child's records. So access can look very different. It could be the school lets you know, hey, Monday from 1 to 2, you're welcome to come look at your child's records. It could be that they provide you a link, a Dropbox link, and then you can download everything that's been scanned. It could be the school will ask you if you want printed copies. If that's the case, they may charge you a fee for the printing. The other law that is wonderful for students who do have an IEP is under IDEA. And in that case, students or parents are have the right to their records without unnecessary delay and prior to any IEP meeting. So these are very important. And two, each law has a different timeline. With FERPA, the school has to provide the records within 45 calendar days. With IDEA, it again is without unnecessary delay and prior to any IEP meeting. So let's say you make a request under both of these laws. If that's the case, it's either the school has to provide either when before the IEP or within the 45 days, whichever timeline finishes first. That's what they have to follow. We often see, we will make these requests, and school districts will always conveniently ignore the request under IDEA and will say, oh, we have 45 days. And I'm like, ooh, but the IEP meeting's next week, so you should get moving on that. We need the records. So, you know, there's lots of ways to address that. So.
Extended school year. So I know it's often referred to as ESY. And there's some really important things to remember. I think people think ESY, oh, it's the summer. It is not just the summer. ESY refers to special education and or related services provided beyond this normal school year of a school division for the purpose of providing FAPE, free appropriate public education, to a student with a disability. This could be before or after school. It could be over winter and spring break. It all depends on the individualized needs of the student, right? It's individualized. ESY is not just this cookie cutter. We're only going to provide it, you know, in the summer for 4 weeks. You also want to know the criteria, right? So the IEP must determine whether the benefits the child gained during the regular school year will be significantly jeopardized if the student does not receive ESY. The team must determine whether critical life skills will be impacted. And the criteria to determine this includes the following: regression, the likelihood of substantial regression, the degree of progress, whether the student's degree or rate of progress towards those goals, objectives, or benchmarks, if appropriate, will be jeopardized. Are there emerging skills, or is the student in a breakthrough? You know, and whether the interruption in services and instruction on those goals by the school break would be jeopardized. Also, are there interfering behaviors, right? So whether any interfering behaviors could be ritualistic, could be aggressive, or self-injurious behaviors are targeted by the IEP goals. You know, that have prevented the student from receiving benefit from his or her educational program during the school year. Also, we want to look at the nature and severity of the disability, whether the nature and severity of the student's disability are likely to significantly jeopardize. So those are some key words: significantly jeopardize the student's education. There's also special circumstances and other factors that we look at when we're looking at ESY criteria. So some of those examples might include the ability of the child's parents to provide educational structure at home, or maybe the ability of the child to interact with children without disabilities, areas of children's curriculum which need continuous attention. And as I said before, ESY should be individualized, right? School districts may not limit ESY to particular categories of disability. For example, they cannot only provide services to students with intellectual disabilities. I was at a meeting earlier this week and a speech and language pathologist said, oh, ESY is just for those really, really low kids who don't speak or have really bad behaviors. Nope. Did I correct her? Yes, I did. They cannot unilaterally limit the type, amount, and duration of those services. Again, we see this all the time, you know, when a school district says, okay, ESY, it's going to be for 4 weeks from June 1st to June 31st, and it's going to be 3 hours a day. We're going to do 8:30 to 3:30. Nope, they can't do that. They cannot limit it only to summer, and that criteria is not individualized to what the student needs. So a 4-week, you know, a summer 4-week program may be appropriate for your child, but it's an IEP decision in which the students' individualized, there's that keyword, individualized needs are examined. You know, I think sometimes school staff, they may not know that it's not just for the summer, or they've been told by, you know, their administration, they've been told something differently, right? We always want to assume positive interactions when we're meeting with teens. It could just be that they really don't know, or they were told something completely different.
I think that's a really good point. I know when when I was working in FCPS, it was very much asserted that it was the summertime. So I think that's a really great point. So this is what I consider the best kept secret. And that is an independent educational evaluation, or an IEE. Oops, I clicked too much, sorry. So the regulations state that the parent has the right to an independent educational evaluation, or an IEE, at public expense if the parent disagrees with an evaluation obtained by the local educational agency. What does that mean? Let's say the school conducts an evaluation and you don't feel that it had the right information, or it didn't thoroughly evaluate the student's deficits. That's when you may want to consider an IEE. And the school district has two options. They can approve the IEE, or they could take it to due process. Luckily in Virginia, most of the time they approve. I personally have not encountered where it's gone to due process, knock on wood. I don't think anyone in our firm actually has encountered that. Oh, just one, oh, once?
I'm in the process.
Oh, the process. Oh, goodness. So what that means too, the school district has to pay a private and independent evaluator to basically redo the evaluation. And the family doesn't have to pay for anything. It really is a way of gathering correct, accurate, and thorough information, because school districts are required to evaluate any suspected area of need, and they don't always do this. So, the regulations also state that a parent is entitled to only one IEE at public expense each time the public educational agency conducts an evaluation with which the parent disagrees. You do not even need to state what you disagree with. You just have to request it, and they have to approve or due process. So, two, it's really important to understand what the difference is between an evaluation and an assessment. And we are finding that school districts do not understand the distinction between the two. To better explain it, this is a template from VDOE, or the Virginia Department of Education, and this is the consent to evaluate form. So whenever a team gets together to consider whether or not there is an evaluation is the process that may include multiple assessments. So it's the overarching thing. I don't know what word to use there. So looking at this, there's lots of areas for the evaluation. There's an educational assessment, psychological, sociocultural, speech language, developmental, hearing screening, vision screening, medical report, occupational therapy, physical therapy, functional vision, observation. There might be other assessments, like I know we see for functional behavior assessment, which is an FBA. These are all of the assessments within an evaluation. So let's say in this evaluation, they decide to do the educational, psychological, and sociocultural assessments. If you request an IEE, you are requesting for this entire evaluation. You may disagree with just a piece of the educational assessment, but when you ask for an IEE, it's for everything. You could request an IEE and say, oh, that educational piece, it's not good. I don't agree with that. And you may get an IEE and just go the route of looking for an independent evaluator who will do the educational. A year later, if you decide, oh, but I also didn't agree with the psychological, you're too late. It's a kind of a one and done deal. The school could always meet again to consider evaluation, but you only get one IEE request per the evaluation. So again, if you disagree with only one of the assessments, The evaluation is that entire grouping. And we get this all the time where the school districts will reach out and say, which evaluations do you not agree with? One, you don't have to explain to them what you don't agree with, but also it's not the individual assessments. The entire thing is an evaluation. So the school district, if they approve it, they will give you information. They'll provide you lists of independent evaluators that they work with on a usual basis. You can use people from that list, or you can choose another evaluator that's not on the list, because also with their approval letter, a list of evaluators, they also give you the evaluator criteria. So as long as someone meets that criteria, they can conduct the IEE. And the criteria is, are they licensed? Do they have, good practices? They're not a felon, things like that. It's pretty basic stuff that they look for. And yeah, that's kind of IEE in a nutshell. Did I miss anything? There's so much about IEEs, but this is kind of the overall general that I like people to know, because often school districts do kind of a crummy job, especially during COVID and everything. And you can have these evaluations, if you were to pay out of pocket, are really expensive. So it's nice to know you can get a really good evaluation and not have to pay for it.
And just something else to note is when they send you, the provider list, they also usually include like a fee cap, right? They'll pay, up to $800 for a psychological or whatever it is. Every district usually has different fee caps. So that's usually in the list that they send along with the criteria.
Mm-hmm. Yeah, and those fees are supposed to be, considering like kind of the average of what evaluators charge within the area, as long as it's reasonable. And that's why they have these caps, is to keep it reasonable, because we've had clients who want to get a neuropsych, and the place is $10,000 for a neuropsych. That is way high compared to like the average rate that we see in this area. So from the school district's perspective, it's to keep it appropriate. Yeah, they're not going to be dishing that out all the time.
Okay, and finally, we want you to know your rights, right? You don't know what you don't know. I can't tell you how many times I've had this conversation with my clients as they might be really upset. Oh, I can't believe I didn't catch that. I don't remember doing that. I don't remember signing that. Or you don't know what you don't know, right? And a lot of times that's why people come to us, because they don't know what they don't know. Anytime you go to, an IEP meeting, the school district will offer you this. They're called your procedural safeguards, right? They'll give you this copy. It's a thick white book, and you'll be offered it at every meeting. It is sort of a boring read, but it's broken up by sections, and it's important to just know your rights, know what's in there. If you're offered it at a meeting, and let's say you already have 10 at home, you can just say, no, I already have them at home, but they are obligated to offer you your procedural safeguards.
Right. And, again, we have people who come to us, they're overwhelmed, they don't know the process. This is a dense read and it has a lot of jargon. So that's it, one of the reasons too, people may want an advocate to help them like go through all this paperwork, all these terms. It can be overwhelming. And, Alicia and I have the special ed background from being teachers and case managers. I can only imagine how complicated it is for families who don't have that education background. It's a lot.
And I'm still learning stuff every day. I mean, Bridget and I've been doing this for 15, not necessarily advocates, but in special education for like 15 years. and there's always something new that pops up, or that we're constantly learning. So that wraps up our presentation. We want to thank everybody for attending. We're happy to take any questions that you might have.
And two, I just want to make sure again, Jan, thank you so much for having us. We were really excited to do this presentation, and really hope we've given people some helpful info to take away. But yeah, we're excited. I see there's some things in the chat. I don't have the chat open, but we're happy to take questions.
Most of them have been answered,
Oh, good.
they wanted email addresses, so.
Great.
Alicia, Alyssa, you put them in there, and so did I, because I hadn't seen you. Okay, there is one question.
Okay, so it
You
says,
see that, Alyssa?
yeah. It says, you say one IEE per evaluation. Do you mean once every 3 years? So it's whenever. That's a great question. So there are triennials, right? So that's every 3 years where they go through the reevaluation process, but it's any time that an evaluation is done. Hopefully that answers your question. So maybe, like, let's say this year they did a psychological and OT, right? Next year they do another evaluation, and it might be speech and an FBA. It's whatever is in that evaluation box. And Bridget, if you want to add anything else.
Yeah, so whenever you see that form with all those different things listed, that's the evaluation. Like Alicia said, there is the triennial. IEP team is required to meet every 3 years to determine whether another evaluation is needed, but it couldn't be sooner. Let's say, especially after COVID, I saw a lot of meetings that were the reeval was bumped up because really needed to have an understanding of what the child's current functioning was. And that's another piece that's really important to understand when you're going through eligibility or reevaluation. The purpose of that evaluation is not just to determine eligibility and if there's been a change, but also to offer that guidance in creating the IEP and addressing each need.
So and just to piggyback off that, Bridget, a lot of times schools will say, oh, your child's still going to qualify for special education services. We don't need to reevaluate them. But it's not just for that. And especially if you have a student who is like in 3rd grade and now they're in 6th grade, there's a lot of developmental things that happen within those years. And so having that updated testing, that information is vital to the team in order to develop appropriate goals, determine what the needs, the services are of that student. So just don't let a team say, oh, we don't need to do it because your child is just going to continue to qualify for special education services.
Mm-hmm. And I think
that answered your question. Okay, so here's another question, and it says, what happened if in the past you signed the IEP and you know that things were missing? When can you go back and request another evaluation? Great question. You can request it now. Like if you suspect there's something else going on, there's some changes, you can go back through eligibility and request that your child be reevaluated.
Yeah, it really depends on what kind of timeline you're talking about. So if you're talking about like a couple of years ago, that's when you would kind of want to make a request through the school district. But let's say it was less than 2 years ago, because there really shouldn't be a time limit in requesting an independent educational evaluation, the IEE. But we find in Virginia, they like to stick to the 2 years. And it's something that we've been, as a firm, really been pushing back on. So if it's been less than 2 years since the school did those evaluations and you don't agree, you're entitled to request an IEE.
I think that's what the question was asking.
Oh, okay. Yeah, sorry, I can't see the chat.
Other questions? Okay.
Oh, okay. Okay, thank you. It was 10/20. So was the evaluation done in 10/20, or that was the the IEP. The triennial evaluation was in 10/2020.
You can always push up the reeval.
Yep.
Yeah, I would, I mean, too, you have to keep in mind, we don't have all of the information, but just the basics that we do know, that, that's what the route I would probably take.
Will you share these slides with me, Bridget, so that
Yeah.
in PDF, and that way I can send them out when I send out a
course.
link to the recording to the individual. Just pop them in an email to me, and that I know a lot of people appreciate getting a copy of the slides just to refer back again,
Yeah, I'm happy to do that. And I can, as far as I know, we mentioned a lot, we got our information from the regulations, from VDOE.
Mhm.
So, I'm happy to provide links to specific things too. But just
That would be wonderful.
yeah.
Are there any other questions? I know it was a lot of information.
A lot.
I don't see any more, but thank you, thank you, thank you. It's always good for me to have a reminder
Mhm.
of the regulations because I've studied them. I've done rights law. I've done, but you don't, unless you work on it every day, you don't necessarily remember it. So this will be a great addition to our website.
Oh,
to
good.
remember, they're all our previous workshops are recorded and on our website under virtual workshops. I have them from 3 years ago. I even still have last year's conference up. I'll take that off when we get this year's on, but some good things. Thank
And
you.
of course, and if anyone, you pop off and you think of other, just general questions, please email us. We're happy to help you.
We appreciate it. It was a great presentation.
Thank you.
Thanks, Jan. We really appreciate it.
Thank you. Thanks for having us.